students, lawyers, teachers, professors, and all others who are interested in what we call is commerce. Let me first of all begin that in these hard times that we are all passing through, and with each day's things going from bad to worse, let me start with a prayer to Almighty, irrespective what caste, color, creed, or religion we belong, to one and only one Almighty to keep us all protected, our families protected, and pray for your health, happiness, longevity, and also that let God bless us all and stop this new normal and bring us back to where we were. We are discussing today what is the beginning or at the threshold of what a youngster would look at a commercial law to become a commercial lawyer. And then we go on to what actually lawyers mean, but I thought it is better to start from what we actually mean as lawyers. In this world order that we are passing through, or were, in fact, when economics was so important for each one of us, especially from the Indian point of view, economy was playing a predominant role because we have in our country people who are not with jobs, people who are suffering right on the streets. We have daily laborers. We have almost 70% of our industry in this regard, which is unregulated, and therefore there are more problems for us. But we as lawyers, whether upcoming, budding, or already in the profession, with the blessings of our teachers and professors, have to play a predominant role. Because in a country like India, especially, unless the rule of law prevails, unless my judicial system is robust, is seamless, it is less costly and expensive, we will not be able to build a democracy that is enshrined in our constitution. So, to me, lawyers play a very, very significant role. It's an extremely serious profession and begins with the first part, and that is that you have to be a good human being. Every lawyer must have within him a good human, not only a handsome or a beautiful body, but a beautiful heart, enlarged heart, not in terms of a cardiologist, but in terms of law, where he can give much more, forgive even greater, and take into his stride or her stride the right to bring justice and truth to the doorstep of people who are today crying for justice. Apart from being a human being, we have to learn to be a person with integrity, honesty, truth. This is not a profession where you have to look at whether a person is running an industry and is making X or tons of money. It's a calling to the bar. Therefore, it's a service to the nation, service to the society. Yes, notwithstanding that, I'm not suggesting that lawyers should not be paid or should be underpaid. But yes, commerce, though one would be a commercial lawyer, but not that he's only looking at the money power in his own pocket. He has to look at how does he resolve, how does he bring truth, how does he bring relationships back to people, so that is his role to ensure, or her role to ensure, that this economy in the country, which has taken a little dip because of the COVID or otherwise, comes back to its rail, and we are able to provide a justice delivery system assisting the court, or even without the court, in the alternative dispute resolution methods, which I'll come to a little later, to ensure that all commercial disputes get resolved, whether adjudicatory or non-adjudicatory, in a time-bound manner, and also in a manner which satisfies both the parties. If it's adjudicatory, I appreciate that one party may still be aggrieved of a decision of the honorable judge, but with the alternative dispute resolution methods available in this country today, and after India has signed the Singapore Convention last year in 2019, I'm sure all my young budding lawyers and students, with the blessings of the teachers, as I said earlier, will be able to become lawyers with aid and the sole purpose of bringing resolution in the society. For that will bring harmony, that will bring peace. And with that, we all will grow, notwithstanding that we are not even looking for a money as the main source for showing our credibility to the society. A lawyer doesn't have to show his chips of gold in his pocket or silver in his pocket to show what eminence does he have for the purposes of giving court assistance or become a mediator or an arbitrator or assist an arbitrator arbitral tribunal for adjudicating any commercial dispute. Every transaction, to my mind, even from buying vegetables in the market to buying a grocery, till I take you to joint venture, amalgamation, insolvency, or joint ventures, everything is commerce today. In that, the elements of commerce will get attracted. Therefore, for a commercial lawyer to understand this first principle is extremely important. Look at the link between criminal law and civil law, for example. Letter of credit, bank guarantee, and on the other hand, Section 138, Negotiable Instruments Act, are all backbones or part of the commerce and part of the commercial world. Bank guarantee is a security. Letter of credit is mode of payment. And when you get that instrument of a check and the same get dishonored, Section 138 of the CRPC gets attracted. We have just got a report from the two honorable eminent lawyers who has now given us ways forward. How do we look at the pendency of 138 cases in the court and how we can resolve these disputes is a question that the Supreme Court is considering, and the matter is sub judice. The report has already been submitted by two eminent lawyers of this country. But having said that, let me start with you to show you that a transaction of buying a goods, for example, though a commercial transaction, yet would be governed by separate statutory provision than, for example, buying an immovable property. While in a Sale of Goods Act or a sale of a movable product, the property in the goods would pass, notwithstanding you have not paid. But that may not be a case, strictly speaking, in a case of transfer of property. Because that, normally speaking, there are unusual situations, of course, where people have agreed to pay consideration, even with respect to an immovable property much later, but those are exceptional, extremely exceptional cases. By and large, when a transfer of property looks at a document or a sale deed, it looks at this consideration has been paid either across the table before the sub-registrar when you're registering the instrument or at the time of execution of that document, which will be prior in point of time. While in a case of Sale of Goods Act, the moment goods are ascertained, supposing I was asked to go to a factory and look at some horns or some bulbs, and I bifurcate them from the main lot into a lot which I intend to buy. The very fact that they are ascertained, price is fixed between me and the vendor, and accept the fact that I have to pick them up later after making payment or otherwise. It could be on a credit basis also. The property in those goods stands past. Therefore, the request that I am making to my friends is that you must look at the statutory provision. Both are dealing with transfer of property. Property does not here means immovable property. Property means property movable as well as immovable. So if consideration is the mode, while when you're transferring goods, the property and the goods may get transferred under the Sale of Goods Act. Yet unless a sale deed gets registered under the Transfer of Property Act, a property does not get transferred. In Delhi, for example, those of us who are aware would be aware that transactions, especially with respect to perpetual leasehold properties, were being sold in Delhi. Not that even today there will be instances where such sales are taking place, but by and large, sales used to be by agreement to sell, by a power of attorney, registered, and a will. The matter was judged right up to the Supreme Court, and the Supreme Court in Suraj Lamb said these transactions cannot be considered as a transfer of property transactions because the statute is clear. You can only transfer a new property by a registered document. And let me deal here with a aspect with many of us, even at this juncture of my age, may not be able to make a distinction. While a sale deed does not require attestation, it requires witnesses, of course, for the purpose of procedure. But a same instrument of transfer of immovable property, like a gift deed, requires attestation in law. Therefore, the purpose of my telling these three aspects was to bring home a submission to you all that when you are looking at a particular transaction, please first examine whether it is a transaction which goes under the Sales of Goods Act, or it goes under the Transfer of Property Act, or goes under any other statute. It could be possible, it could be a government grant. Therefore, the first principle of contract we all learned in our law schools from our respected teachers and professors, that there is a Contract Act which was pre-independence and continues to be operative as of today. Therefore, there has to be an offer and acceptance, a consideration, etc., etc., and then a contract comes into play, unless the contract is illegal for illegal motive and for getting illegal things, or the gratification is illegal. Gambling is not a contract, unless we bring in a legislation to bring gambling into the purview of a natural question in relation to commerce, which we are still far from, and I think rightly so. We are not mature enough, despite 71 years of our independence, to deal with such situation. Misuse in this country is more often than user of a statutory provision. So having dealt with that part, you would now see connected with the sale of goods, that the property passed the moment goods are asserted. Therefore, if something was to go wrong with those goods, the buyer itself would become responsible for it. There are instances where the goods were still in the custody of the vendor or the seller, yet the transfer of property having taken place, and he having not taken those steps with respect to insurance or otherwise, and if something went wrong, it came to the kitty of the buyer. So, request is look at your facts, first part. That's the first principle of advocacy. You must master your facts and then look at provisions of law. Many of us ignore the actual provisions of law. We go by our perception that this is actually a mobile sold, therefore it has to be a Sale of Goods Act. But to give you an example of mobile phone, for example, 125 patents are there in one mobile. And out of those 125, at least 100 would be standard patents, for which a license becomes a compulsory part. So see how a commerce gets connected from a transaction of a sale of mobile phone to a patent law infringement. Supposing I was to sell a mobile phone which contains patent articles or patent components, where I'm violating patent. Therefore, even when I sell it to you, I'm actually infringing patent. Therefore, the commerce is interconnected. So at the threshold, when a lawyer wants to do commercial practice, he has to first understand the first principles of commerce law. And I may add here that every lawyer, irrespective which branch he practices in fact, must read 60% of a material which is not connected with law. Then he'll be able to appreciate a transaction. Much more than a person who is not versed with niceties of that transaction. Otherwise, for a layman, I'm not talking from a lawyer's point of view at all. Consequently, once you muster your facts, you would know it's a gift. Is it a release deed? Is it a sale of goods act? Is it a sale of transaction of immovable property? And then see the distinction within that subheadings come. It could be a sale of a agricultural land, then the responsibilities are different. Statutory provisions become different. For example, in Delhi, there's the Land Reforms Act. There's a Transfer of Restriction Act here in Delhi, which you need permissions for order to transfer a agricultural land. And then in many states, unlike we have recently found a notification issued by the central government saying that we all can buy and all land in Kashmir as union territory. But must be careful to see that that land permission to everybody is not agricultural land. It's other than the agricultural land. Consequently, it becomes essential for us to see what is the product of sale in any commercial transaction. Coming from Sale of Goods Act to Transfer of Property Act, let me take you now. We are used to have a Punjab Courts Act in Punjab when Punjab was won before partition. Post partition also, the Punjab Courts Act continued. And there used to be a commercial judge under the Punjab Courts Act. But in 2015, the legislature brought about, the parliament brought about what we call the Commercial Courts Act. At that time, the name was a little larger, but it was shortened in 2018. And the section thereunder defines to a very, very large extent almost every transaction of sale, which is a commercial transaction. Now, see, the law made a distinction here. While in normal parlance, a sale of an immovable property would be a commercial transaction by all means. But under the Commercial Courts Act, when it became non-residential, it became a commercial property. It became a commercial dispute. And the law brought in a change in the Commercial Courts Act in 2015 as amended in 2018, that under provision of Section 12 capital A, the legislature brought a Section 12 capital A, which mandated that you must go and resolve your commercial disputes before you enter the gateway of court, unless there are exceptional circumstances. The word that is not used in the statute, I am using it because the intent of the legislature seems to be that mandatory, when the word used is mandatory mediation, it means you must follow that mandate. So if I want to circumvent that by only moving an application to say, I want an interim order and therefore I don't want to go to mediation, I think would be doing injustice to the intent of the legislature. The legislature meant was 99.9% you will go to mediation first, unless, of course, there are exceptional circumstances where you find something, the subject matter in itself, the other side wants to finish it, and you will not be left with anything to adjudicate upon. Yes, certainly, the intervention of the court becomes very necessary. So the law has to be interpreted as lawyers as to the intent of the legislature, what is the object it seeks to achieve. In a commercial dispute, the Commercial Courts Act after the amendment of 2018, what it needed to look at, what it actually objects to all of us to look at is what is the intent therein, that commercial disputes being disputes which need to be resolved immediately, we must look at them with different eyes and consequently provided mediation as a process. Now, I must share with this august gathering that in 2002, the Civil Procedure Code, which is really the procedural mother of civil law, was amended and Section 89 was added, which brought the concept of mediation, apart from then conciliation, apart from judicial settlement, etc., etc. And for the first time, we saw in 2006, centers started emerging in the country with respect to mediation. Though I understand after Chief Justice Borde has took over as Chief Justice of India, His Lordship passed an order or made a request by an order. And the Bar Council of India has responded to that. And now mediation has become compulsory in our legal education situation. And by this forum that I am addressing today, let me take advantage of the same and request you all that we already have mediation centers all over the country. Most of the mediation centers are doing well, though, of course, exceptional like Delhi is an exceptional that. I was told yesterday that in Karnataka, the settlement went above what Delhi was. But then Delhi has a peculiar situation, and that situation is our problems that come to Delhi are extremely complex, are extremely intertwined between parties, between commerce and other parts. Emotions also get involved many times, even in commercial matters. And consequently, our rate of 59% or 60% with respect to what we see as commercial disputes under the Commercial Courts Act, I think is enormous. And I must pay compliment to all those mediators and everyone, honorable judges who are taking part in the mediation course today to ensure that this new system, new normal, if I call it, as we say with respect to COVID, has been taken over by lawyers as mediators in the very forefront. They're actually the forefront warriors now today on the commercial disputes, and they're trying to resolve the same. But we have at the same time now an organization, an international council for mediation called Madhyam. So any one of you is interested in looking at what are the various yardsticks, what can be that structured situation with respect to mediation, you can always contact them with respect to the same. And I just wanted to add something that mediation is taking the forefront also with respect to what we brought in 2016. For the first time in this country, we brought a legislation called Insolvency Bankruptcy Code in December 2016. And in 2018, within 2 years, the jurisdiction under the said code got the World Award as one of the best jurisdiction in dealing with restructuring and insolvency cases. But in that purview also, we have now introduced mediation, especially after the legislature has now notified, the government of India has notified the insolvency provisions to apply to individuals for guarantors for the time being, and which also jurisdiction falls within NCLT, what we call adjudicating authority. And even during this COVID time, only from my personal experience, I can say, I think 7 cases came my way with respect to mediation. And I'm happy to say that 5 got resolved. 1 is still with me because parties are 2 groups looking at certain aspects and audited balance sheets, etc. And I hope that will also get resolved. Because the 7th one had a little fraudulent intent by some officers, so it was not possible to bring purely disputes with respect to offenses against state within the mediation process to resolve it. But I'm sure some parts of that dispute can always be resolved even through this process. So to my young friends, I request you that you must also look at, while you are wanting to become a commercial lawyer, to look at your own gentlemanness, 2, what kind of provision, what kind of dispute is it, 3, integrity, 4th, look at the principles of law in various statutes before you plunge in to do anything with respect to the same. Now take for example IPR. Now in IPR I can start from copyright, go to trademark, jump to Designs Act, and then go to Patents Act. And to give a very small example, a fountain pen that all of us carry, with today's situation where so many times you find the electricity going off, if one of you was to put a bulb, a psycho bulb now it is specifically called, you will be entitled to, probably, if you look at it from that point of view, a new technology that you're bringing in, and you will be entitled to get that as a patent. It could be a pencil, it could be a surgical instrument, for example. A doctor is operating in the operation theater and the lights go off. That bulb automatically comes in to his aid so that the life of the person who's being operated can be saved. Now, these are aspects with respect to commerce only. Commerce is part of it, because when you are infringing If I was to be the patent holder, or I was the one who has invented that, or but who has been able to bring this change, if somebody else was to copy it, obviously a dispute in respect of commerce will only arise. But having said that to you, the request I am time and again making in between is that commercial disputes need to be resolved at the right earnest, whether by adjudicatory method or by mediation, as we see that. You will find under the Arbitration and Conciliation Act 1996, Chapter 3, we have a conciliation chapter there. Now, conciliation has been, till mediation took its forefront, there was hardly any case, though if you ask me personally speaking, right from 1926 when the Trade Union Act came into place, which is pre-independence, the concept of conciliation was there. But world over, you will find a sea change is coming up now, especially after the United Nations Convention, which is normally called now Singapore Convention, that we are intending to do away with word conciliation and bring mediation into forefront. Because mediation is a process which empowers the mediator, who is merely a felicitator, to empower the parties to come to a decision themselves. And to give you a more specific example for us to understand it, in a joint venture which would be governed by Contract Act, by if it is a joint venture between India and some other country, so FEMA will come into play, the SEBI will come into play, provisions will apply, and consequently, ultimately, if it's an incorporated company which is bound to be, the Companies Act will come into play. Now, therefore, it's a blending of various statutes into one transaction in coming to a joint venture. So the request is every statute's words must be read. In fact, this morning, a question arose for an opinion sent to me was that if government gave me a land and I built my own property over it, and I have committed no violation, I have taken municipal sanctions and constructed property by my own funds, can you immediately take possession of the property, notwithstanding the superstructure is mine, and not giving me time to either give me compensation for it or even ask me to remove that part? But there could be situations where the structure is so heavy that I can't remove it, so the government will have to compensate me. So the question that I am requesting is, this also is commerce. Government has, over, especially after Dr. Manmohan Singh came in and he opened the economic doors of this country, we found thereafter there have been, irrespective who has been at the helm of the affairs, we have been seeing there's a one after the other economic reforms brought into this country only to ensure that India is an economic world power. And I'm sure, but for COVID-19, we would have done this maybe in the next 2 years. Maybe COVID brings temporary hindrance and impediment into it, but I'm sure we as Indians face challenges, are capable of facing challenges. We'll face this challenge also and come out rightfully and very conveniently. Coming back to our provision of the commercial law, it brings me down to a situation, for example, even in transactions, which also will attract what we call is the sovereign power, which is income tax, sales tax. Now we have GST, for example, in the country. A question that a commercial lawyer must also appreciate is, while he is doing a transaction of property, what will happen to the person who has got the money? So from the income tax point of view, he must examine also that whether it's a capital gain, a short-term capital gain, or a long-term capital gain. Because ultimately we find many times when we settle disputes and we say Mr. Chandhiok will give away his property to A, B, and C, which is my brother or a sister, we don't realize that Mr. Chandhiok will be subjected to capital gain under the Income Tax Act. And one, he has given up his share in the property. The second, he'll be bound to pay income tax on or capital gain tax on the same. Therefore, a commercial lawyer, while examining a document, has also to examine and must examine with respect to what we need to look at as to other aspects of the matter, for example, in the Income Tax Act that I've given you. Knowing the time at my disposal, let me bring you to the aspect that what actually this profession is. As I said in the beginning, this profession is calling to the bar. This profession requires extreme hard work. This profession requires, actually, I keep saying this on a lighter vein, that every lawyer actually must commit adultery because he first gets married to this profession and then only probably gets married later. Of course, there's no bar. People have got married earlier and now also come into this profession. There's no bar on that. But still, to my mind, till you actually go into this profession, get married to this profession, work hard and stride over it, it will not be possible for us to succeed in this, making the judicial system workable for that common man who's crying for justice for years and years together. Time has come today. There is very high responsibilities placed on the shoulders of my young friends who are now coming to the profession or have just joined the profession to ensure that this responsibility is discharged to the best of their ability. Today, unfortunately, technology is playing a very big role. I would not call it unfortunately, fortunately, if I look at COVID, but for technology, we would not be even talking to each other today. But yes, in a legal profession, while video conferencing or probably streamlining of these webinars are possible to exchange our views, talk to each other, we are able to discuss the principles of law. But at the same time, it shows me from the groups that we people have, or otherwise, people are looking at templates today. I write to somebody to say, has anybody got a suit filed with respect to a commercial transaction in relation to an immovable property? Somebody will file a petition or say, can you give me a draft of an application for transfer of goods or transfers of companies or transfer of joint ventures? And therefore, we just cut, paste, and copy, which I request with all humility at my command, is not the calling at the bar. We must bring originality, innovate new ideas. The principles, law is not static. The same statutory provision. Please look at Article 21 of the Constitution of India. Article 21 did not give what we have today got, but the assistance to the Honorable Supreme Court and the High Court, given by lawyers, expanded the meaning of Article 21. Therefore, what we saw in the writing in the Constitution of 21 is not what we are interpreting 21 today. Similarly, right to life, right to livelihood, right to live with dignity, women's right to property, everything is brought within the ambit of Article 21. Therefore, when you are looking at a statute, please look at something innovative. Please don't go to SCC Online. I'm not against SCC Online, but we can't go to SCC Online, look at 3 precedents, and then start making our provisions. No. You, as young lawyers with fresh minds, please look at these statutory provisions afresh. And I'm sure, God bless you with all, you have capacity, capability, and talent at your disposal. The teachers have put that, imbibed into you, the rule of law, and interpret those sections afresh in the light of these changed circumstances. Look at one principle of law under the Contract Act, though not really strictly speaking under the Contract Act, but part of the contract, force majeure. So we feel that after COVID-19 or 25th of March 2020, till the lockdowns were put up, everything should be suspended. My obligation to pay rent as a tenant must go. My obligation to deliver goods in time of the motor part articles or any other article that I'm manufacturing should be dispensed with. That's not the correct position in law. Consequently, this force majeure itself gave us so much of interpretative rules that courts had to intervene to say what force majeure is. And to give you an example, force majeure, whosoever invokes, it's a very high pedestal doctrine that one has to look at. I must prove that I have taken all precautions that were required of me, that were expected of me, yet I could not perform. Or there was actually an activity. In fact, many of the force clauses, because nobody thought one day we'll have COVID-19 in the world. So nobody made clauses as that remunerated, as that detailed. And force majeure is not playing a significant role, unless, of course, the government brought in the legislation. Here to bring you another piece of information, many of you may be knowing it, that in Singapore, for example, they brought a legislation which said force majeure, irrespective of your contracts, would apply to everybody. And they defined what force majeure would be. In our country, we have so far only done with respect to MNCs, small sector undertakings. Plus, of course, we have gone to construction industry with respect to the same. But it's time that legislature will have to look upon people like you who have knowledge of principles of law. Principle of law is the same. I don't think any principle makes a change. Principles underlying common law principles remain the same. But by a statute, we make a departure. As I said to you in an Income Tax Act, for example, till we brought in Benami Transaction Act, we under the Income Tax Act brought a provision which said if I buy a property in the name of somebody else, or my brother or my friend or somebody, I must continue to disclose that in my income tax return as that I am the actual owner of the property. Now, similarly, with respect to shares in a company, that obligation has been cast under the Companies Act. So the principle of law doesn't change, actually speaking, except that looking at the circumstances, the facts of a case, or the scope of that dispute, or subject matter of that dispute, the provisions change in view of the special statutory provisions that we have made under the Companies Act and that under the Income Tax Act. Therefore, my request to you is that this profession is not for those who are looking at what we call today, which are red notes in 2000 or red color notes in 2000, but are looking at, first of all, how do you respect this law? And consequently, you must respect that brief that comes to you. I can give you an example. When I joined the bar, on the very first day when I went to my senior's chamber, I was given a file, a code of civil procedure, and Delhi High Court rules and orders, and said, from today, you cease to be a Sikh. So I thought I'm going to become a lawyer and I don't want to come and change my religion. But he said, if you respect this file, if you respect this law to the best of your ability, do hard work, I assure you, you are actually doing service and actually making prayer to God. Because ultimately, what are you actually doing? You are wanting truth to prevail, which is the first notion of any religion. And second, you are wanting justice for those who are victims at the hands of somebody else. And let me end this today's thing by giving you a situation, an experience in life that may come handy for you to understand what this lawyer means. Well, I am not claiming that all of us are above board. There could be black sheep amongst us also. But by and large, I find lawyers, unless there is a compulsion to him, is by and large honest. And he's supposed to be honest. Integrity should be his second feature after he's become lawyer, after being human. His humility should be his third aspect that he must look at. And many people ask me this question, and I respond in two ways, and I want to respond to my young friends. Each one of us, whether I go to a Gurdwara or you go to a mandir, or a Muslim prays his nawaz, or a church, we all bow our hands when we go before God. What's the purpose? The purpose is only one. That I feel each God, give him any name that you give, only tells me how I must look down. And when I look down, जब मैं माथा टेकता हूं, तो what am I actually saying? I'm telling God, give this head mat, give me that knowledge, give me that strength, that I am able to be a useful human being to this human society where I have taken birth. Actually speaking, that's the main part. And to bring you to a lawyer consent in this regard, I was speaking in Lincoln's Inn one in London, and after my address, a question was asked by a youngster that the country has been independent for last over 65 years. I'm talking about 5 years ago. But you still call your honorable judges my lord, which is a copy of the British. So when you will stop looking at British for your judicial system? So I had to respond, and I want to tell your friends, what did I respond? I said, in my country, justice can only be done, I believe, irrespective of my caste, color, and religion. Justice actually is done by God. He alone knows how to do justice. He alone has that capability and capacity, no doubt. When I bring an honorable judge to that position, that he becomes an honorable judge in the court, and when I call him my lord, I only bow my head as if I am bowing before God. And when I call him my lord, I actually tell him, I remind him actually, honorable judge, that God has bestowed on you this honor to do justice. So don't betray the God. Do justice in this case. Therefore, I call him my lord. And it is Britishers who copied it from India, not their vice versa. And I must tell you with sense of pride, a standing ovation was given to me with all that Britishers and everybody in that audience. What I am requesting you, you must have confidence in you. And I am proud to tell you today that Indian lawyers are today in every part of this world. No meaningful law firm exists without an Indian talent in it. Our talent cannot be beaten by anybody. We are no less than anyone else in this world. Don't look at Britishers, don't look at Americans, don't look at anybody else. Look at yourself, and you are the best. And when you go with that confidence, be prepared with your statutory provisions, be prepared with your facts, and bow down before that God and tell him, my Lord, I assure you, this country's judiciary has done wonders. And to give you an instance where we keep fighting with Pakistan every day, but I keep telling people that a time was there in Pakistan when the Chief Justice of Pakistan was thrown out overnight. A petition went filed by lawyers there, and 17 judges sat down to hear that petition. And when the judgment came, 19 judgments of the Honorable Supreme Court of India and some of our high courts was quoted in that judgment. Should we not be proud of our judges? Should we not proud of those lawyers who assisted those honorable judges who rendered their decisions? So be proud of yourself. Be a proud Indian. Be a proud lawyer. Go with that confidence, yet with humility, yet being a human, and God be with you. Best of luck to all. Best of luck for coming and venturing into this profession, which I am sure will take you to heights in times to come. Thank you very much.
Thank you so much, sir. Sir, there is a question.
Yes, yes.
How to investment issue related to commercial litigation?
How to investigate? How to
Yes,
investment
sir.
issues?
Yes, sir.
Well, I do not know, to be honest with you, the question is not clear to me, but I can only look at it from the point of view in a commercial dispute relating to investment. How do you go about it? Now, it is possible that when I entered into an investment agreement, we had in India, most of us used to do this, that we enter into an investment agreement. And I used to say, hey, Mr. Foreigner, you are investing into me. I will give you 20% or 10% as benefit, irrespective what the company does. This question came before the court, and the court said such a provision is not enforceable in law. You will have to go to the market position on the date when you want to exit out. And I must explain this part along with this part that till we brought IBC in 2016, entry was possible for people especially from cross border, but exit was not possible. And now with this resolution process coming in, I cannot ask for a corporate debtor to be wound up straight away. I have to go for a restructuring. And if restructuring does not happen in the timeline banner provided therein, then only liquidation comes in. So at this time, when reconstruction takes place, it is possible for that investment person to get out, to go out, seek exit on whatever terms the resolution process ultimately gets passed. The resolution professional looks at it under Section 30. Then the NCLT, which is called adjudicating authority under the IBC, then approves that plan. Once that plan is passed, the investment person can go out. But when you are looking at investment into this country, please look at again all commercial dispute, all commercial laws to see is there a compliance with respect to the same. Once you comply with law, then investment in this country is far reaching today because we need, even take for example stressed assets. Today the insolvency had to be suspended by the government only because we didn't get resolution applicants to take upon the assets which are existing today and use them for the economy of the country. So we're expecting things will move better. We'll have COVID situation better next year and probably land up that. But investment can be straight into an asset. Investment could be in a fund. Investment could be with respect to an immovable property. All things are governed by different provisions of law. So you have to examine each provision with respect to the same. So it will be a commercial dispute. There's no dispute on that part. It will be a commercial dispute within the meaning of even the Commercial Courts Act. However, it could be possible that the investment could be violating SEBI, could be violating FEMA, could be violating something else in this law in this country, and maybe the funds coming from a source which we today call in common parlance are tainted with something else. Therefore, all this must be looked at from the person who has questioned me. And if there's anything that he wants me to ask, he can write to me. I'll respond to him. This is what I could understand from his question, and I've responded to it.
Sir, just want to know your opinion on a career in corporate and commercial law after doing LLM.
Well, I find career in commercial law as one of the best careers. Not that the other careers are bad, but today with the commerce being with every part of our life, actually part of our daily life, in fact, is commercial today. I buy something, as I said, started by saying so that you buy something, it's commercial only. It's a commercial. I go and buy a fountain pen, it's commercial. I buy a toothpaste, it's commercial only. However, the question that you must ask yourself is, are you ready to put in, first, whether the common law principles are imbibed into you? And many of us from law used to feel at my time, not today, please with respect, that where people used to say he has not got admission elsewhere, that he has gone to law. But that situation has changed today. Consequently, you have attended your classes, you have understood the principles from your teachers, which are imbibed into you. Those principles, if you are enshrined in you, and you have intent to look at commercial law, the career is extremely good today. And I want to bring home something here more important than that. Many people feel we have now reached a par of situation in law. No, I don't agree with that. The top is still vacant. There are so many vacancies at the top. We need lawyers who can bring innovative arguments. We need lawyers who can do innovative work. We need lawyers who can draft innovatively and bring something new covenants because new normal has come in. The new normal must bring new changes. And we can't use those old 20 years old templates today to do our practice as law. Therefore, everything is changing. It is your aptitude that you must, and to be a commercial lawyer, if you ask me personally, you must spend at least 1 year in a district court where you will be able to have much more opportunity to look at commercial disputes, then shift yourself to whatever branch you want to look at or whatever court you want to look at.
Sir, what is the capability and extent of covering online commercial transactions through the commercial litigation?
Well, capability comes with your hard work. Nobody is born capable. You may be a born genius. Yes, I agree. But capability gets, in fact, what are we saying today? I just said I took the name of Madhyam, for example, before you. We are capacity building today. So the moment a matter comes to you, you will build your capacity from one to the other, to the second, to the third, to the fourth. And that's where your capacity will be built. Capacity can't be built only by law school. No law school can give you that capacity because obviously the situation is changing. Law school is meant to give you the principles of law. It will teach you what law is. But how will you apply that law? How the law has changed over the period of time. In fact, my humble request to my dear professors or teachers who are in this webinar today is that teachers must update themselves as we lawyers must do to see what are the new amendments that are coming and must apprise our law students of those amendments because it's important for them to understand how a provision gets changed by one word here and there. In fact, for a commercial lawyer, especially, even a punctuation of comma, semicolon, and full stop will make a difference. Therefore, if you have that, and the capacity will build with your time. Capacity won't be overnight. Nobody was born like that, boss. Nobody knows law right from the mother's womb. We all learned whatever little learning we have done. So over a period of time, your experience will build your capacity. But yes, if you keep those fundamentals that I said today, integrity, being a human, doing your job well, and being respectable to your brief, that you read it so properly, so thoroughly, and do justice to it, I'm sure, I have no doubt that your capability over a period of time would actually bounce much more than what you even expect yourself.
Thank you, sir. Thank you so much. Now there are
Thank you,
no
Ji. Thank
questions.
you, everybody. Best of luck to
Thank you, sir.
everyone. Thanks a million. God bless you all. Have a great weekend. Bye bye.
Thank you, sir.
Thank you.